Welcome to the March meeting of the Riverside County Bar Association. My name is Paul Gretsch, and along with Lori Myers, I'm the co-chair of the criminal law section of the Riverside County Bar Association. Lori cannot be here today. A little story behind that. There's a visiting judge out in Banning who she said, I'd like to be present. I'm the co-chair and I'm an incoming president of the Bar Association, so I'd like to be here for an important event. And the judge said, that's not good for us. So she can't be here, but sends her apologies. But I want to thank her for the effort she put forth to assist in putting this together. Neil Okazaki, our president, can't be here as well, and he has asked me to stand in and to moderate the event because he could not be here. So ordinarily, we recognize each and every one of the dignitaries. There's elected officials present, there's judges present, there's appointed officials, but time is short, and I'd rather hear from the candidates, and I think you would too. So today, I think what we'll do is we'll go long on substance and short on ceremony, if that's all right with you. One other thing, lunch was provided by Carla Magana, who sponsored this event. And she sponsors a number of events for the Bar Association. It makes it easy for us to get people here, and we owe her a thank you. And so please. One other thing, we are being streamed live. And in 24 hours on YouTube, on the RCBA YouTube channel, you'll be able to see this event for free. Having gotten all my announcements out of the way, I want to say that we're very fortunate today because we have 3 candidates running for district attorney, all of them accomplished in their own right. They've agreed to speak to us today in a candidates forum. Each of them is oh yeah. Each of them has been provided with 4 questions in advance, and each of them is going to be given a fixed time period, the same time period for each within which to answer. My paralegal and assistant has graciously volunteered to time, and if you've ever seen mock trial, she will give a signal, 30 seconds, and then time. So thank you, Diane. I appreciate your help. Because time is short and there's lots of information to get, I have a request. And that is, please, if you approve of an answer, if you disapprove of an answer, if you feel the need to make noise, don't. Just shut up. Just shut up. And at the end, if you want to, you may applaud. But the candidate's time is valuable. And the information we're going to get is extremely valuable. So please hold yourself quiet. Finally, for those who are not lawyers, the Riverside County Bar Association promotes ethics, civility, and professionalism. And what you'll see is we're well behaved as a group. And we expect all of you who are not lawyers to move in with our standards as well. We care deeply about the administration of justice, as do our candidates. So please behave accordingly. So with that having been said, seated on your far right is our current district attorney. He's been elected for 2 terms. It sort of sounds like a boxing match, but it's not. He is running for a 3rd term. This is Michael Hestrin. In the middle is an accomplished criminal defense lawyer, appellate attorney, Lara Gressley, and she's also running for district attorney. On the far right is a judge of the Superior Court who's taken leave to run for district attorney. Mr. Strunsky is the gentleman on the far right. He also was a deputy district attorney before becoming a judge. So these are our 3 candidates. And in lieu of an opening statement, I thought what we do today is just ask a broad question, and each candidate will have 5 minutes to answer the question. The first candidate first question will be put to Mr. Hestrin, with the same going to each thereafter. Mr. Hestrin, and you can stand if you wish to respond. I didn't mean that anyone had to sit down. Why are you best qualified to serve as Riverside County District Attorney for the next 4 years? And what specific plans do you have for the office and the administration of justice?
Thank you, everybody, and good afternoon. I've led the District Attorney's Office for the last 8 years through some of the most turbulent times in its history. It's been 2 years of pandemic, shutdowns, the closure of our criminal courts, but it's also been 8 years of justice, so-called justice reforms, and radical policies coming from Sacramento and Bay Area politicians. And despite these challenges and despite this adversity, the District Attorney's Office in Riverside County has remained one of the most productive and efficient DA's offices in the state. And our county has remained one of the safest places to live in Southern California, and if not, the entire state of California. Let me start with the last 2 years during the pandemic. Recent stats came out by the Judicial Council that shows that during the lockdowns, during the pandemic, Riverside County DA's office did more jury trials than any county in the state of California except Los Angeles. We disposed more cases than any county in the state of California except Los Angeles, and they have 4 times our population. We filed the 4th highest number of felony and misdemeanor cases in California. And so despite the incredible challenges of closing the courts and the disruption of our workforce, we worked hard, and the men and women of our office made sure that they worked hard to keep the same level of service for the people of this county. Let me talk about public safety quickly. We are facing a crime wave across this country, across this state. And you hear it all over the news, and no one is spared, and we're not spared. In Riverside County, our violent crime rate and our homicide rate has gone up in recent years. But if you do a fair comparison between our county and our neighboring counties in Southern California and other counties of similar population, you will see that our county is among the safest places to live in the whole state. Let me give you an example. California Attorney General's crime stats for 2020 show that the homicide rate in California went up a stunning 31%. Nationally, according to the FBI, it was 27%. Riverside County went up 10% in 2020. San Bernardino, 24%. Los Angeles, 34%. San Diego, 31%. Alameda County, 51%. And that's the same population size as ours. San Francisco, 20%. So yes, our homicide rate has gone up, but not as bad as it could have been in places where they have terrible policy. And I want to note one thing. Statistics recently released by the coroner's office of this county show that the 2021 numbers our homicide rate has gone down 26% in 2021. And so, yes, we are facing the same crime wave as everybody else, but our policies have worked and kept this county safe. Let me tell you how we've done that very quickly. First of all, I believe in enforcing the law as it's written, not as I wish it was written or anyone else wishes it was written. Our job is to faithfully execute the law. Our job is to enforce the law and seek justice. And we take a tough stand and a hard line against murderers, including fentanyl murderers and gang members, people who use guns and rapists and child predators. And I don't apologize for that one bit. I'm going to continue to do that to keep the people of this county safe. And in the next 4 years, I'll follow the evidence. I'll be just and fair like we have, but I'm going to continue to prosecute cases vigorously. But it's not a one-size-fits-all. We also have led the way in our collaborative courts. That's a key to breaking the cycle of recidivism. And I'll talk more about that in a few minutes in another question. 2015, I started a crime prevention unit. Our prosecutors and our advocates work in every single school district, working through the SARB process, which is Student Attendance Review Board, to keep our kids in school and keep dropout rates low. 70% of people incarcerated in this country lack a high school diploma. And so our employees work hard to keep our kids in school. That is an incredible investment for the future of our county, and it helps keep the crime rate down. So in sum, in the next 4 years, well, let me back up. I take a balanced approach. I take a common sense approach.
30 seconds.
A pragmatic approach to solving the issue of crime and public safety. and I'll continue to do that. So on the serious and violent cases, you can expect our office to be tough. When you're talking about our youth, we're going to reach out to them and try to deter them from criminality and make sure we do everything we can to prevent crime. In the next 4 years, I'll do everything I can to make sure that our office becomes the best DA's office in the state and that the county continues to be one of the safest places to live in California.
Time.
Thank you, Mr. Hestrin. Ms. Gressley, why are you best qualified to serve as Riverside County District Attorney for the next 4 years? And what specific plans do you have for the office if elected?
Hello, my name is Lara Gressley. Growing up the youngest of 6, I was often blamed for things I didn't do. Now, this created problems for me and for my parents, who had to sort it all out. And I think I was about 5 years old when I learned the word justice. I quickly figured out that justice meant truth. It meant that the wrongfully accused would be exonerated, of course, and that my sibling who actually committed the crime would be the one who was punished. Well, it didn't always work out that way. Maybe this explains why I've spent my career as an attorney working in our criminal justice system. I've been an attorney for over 19 years. During that time, I have seen my fair share of injustice. I've seen guilty people go free while innocent are convicted. And I've seen victims of violent crime left with no justice at all. As your DA, I will work hard to make sure that guilty people are not going free and that innocent people are not getting convicted, and also that victims are getting the justice they deserve and the services they need in order to be restored. I'll work hard on crime prevention because I believe in taking a proactive approach to criminal justice. And I believe that recidivism is a public safety issue, so we need to work hard on rehabilitation to make sure that people are not reoffending. And that will definitely be one of my highest priorities. Now, I think that the problem in our system is that things have gotten so distorted because it's a simple concept, really, that innocent people go free and that guilty are punished appropriately. But why has it gotten so distorted? Why is it so out of whack? And my perspective is it is out of whack. I suspect it has something to do with politics, with money, and with power. But I am not motivated by any of those things. I am motivated by God, by hope, and by an honest desire to make us all safer. So we need to do things here differently in this county. One thing that we need to do also is we need to tackle our jail overcrowding problem because it is causing all kinds of issues. Roughly 80% of the people that are in our jails here in Riverside County today are those awaiting trial or resolution of their cases. They are presumed innocent. And what ends up happening is that if someone is convicted and sentenced to jail, they don't end up serving their sentence because there's no room. So we have presumed innocent people staying in jail and convicted people being released. This is part of the distortion that I'm talking about. And we need to find real solutions. And as DA, I will have an impact on this. I can guarantee you that. It also wastes thousands of taxpayer dollars to have needlessly lengthy pre-sentence incarcerations in our jails. It costs approximately $60,000 to house one person, to incarcerate one person in our jail for 1 year. We need to stop wasting that money. We need to start working on real solutions. Now, my unique set of skills and experience is going to serve this county well, because I will have innovative solutions. I have a different perspective. And that perspective allows me to see problems that many others cannot see. And if you cannot see the problem, you cannot fix the problem. But I can see it, and I'm going to fix it. And I'm not going to stop until we find real and lasting solutions to these problems. If we want things to change in our criminal justice system, we need to start electing different people to the position. We need to make a different choice. Now, you heard the introduction that Mr. Gretsch gave, which said that I have been a defense attorney, an appellate attorney, and now a habeas lawyer. What I do right now is try to free innocent people. That's what I do for a living.
30 seconds.
And I can tell you that I have unique skills that are going to help this county solve our biggest problems. And I guarantee you, I will not be releasing guilty people. I will not be making us less safe. I will be taking a holistic approach to prosecution that is only going to end up making us safer. I am the change that this county needs, and I am the right choice.
Time.
Thank you.
Thank you, Ms. Gressley. Mr. Strunsky, why are you best qualified to serve as Riverside County District Attorney for the next 4 years? And what specific plans do you have for the office if elected?
Okay, thank you, Paul, and thank you everyone for coming today. Thank you to Mr. Hestrin and Ms. Gressley for agreeing to this forum. So on January 19th, right before I stepped down from my judgeship, I took my daughter to Starbucks. She's 11 years old, and I sat down with her and I told her I was running for district attorney. She, of course, asked why, and I told her that as a judge, I felt I could not fix the problems that I saw. I told her that I could not merely stand aside and watch as we become less safe, less fair, less effective, and less compassionate. But what I tell all of you today as I run for district attorney, because I am convinced that Riverside County's criminal justice system is on a perilous course. I've been a prosecutor for 15 years and a judge for the last 5. And I've handled thousands of some of the most serious criminal cases for 2 decades now. But I am the only one up here that has actually served in multiple criminal justice roles. And this is critically important. Perspective matters. Perspective has changed. I sit there on the bench and I have a front row seat to the criminal justice system with no dog in the fight. That has given me incredible clarity. So I've been out there talking to the community. And it turns out Riverside County's criminal justice system is #1 in a whole bunch of areas. We're the #1 county in increases in the homicide rate. Despite what Mr. Hestrin says, the homicide rate has gone up double-digit percentages in 5 out of the last 6 years. We're the #1 county in sending people to death row, yet no one has been executed in a Riverside County conviction since 1961. We're #1 in the amount of money that our district attorney receives from police units, yet he has mandated oversight over officer-involved misconduct. We are known as imprisoning children at a rate 2.5 times the state average. And we are a leader in prosecuting children as adults, yet we have no comprehensive juvenile diversion program currently. Make no mistake, this election is about a choice about the future of Riverside County's criminal justice system. A choice between merely talking tough on crime and being effective on crime. So time is tight today, but here are 5 things we can do to be effective on crime. We must direct resources toward prosecutions that are actually proven to make us safe, rather than mindlessly racking up hollow statistics and headlines. We need to recalibrate the filing unit. We cannot have an overly aggressive filing practice and overly restrictive disposition policy. We need to have fair balance on the front end and on the back end. We need to be flexible and fair throughout the process, because those initial evaluations of cases are often based on imprecise and inaccurate and sometimes wrong information. So we need to be fair throughout the entire process. This question is going to come up later, but we need to file enhancements only when public safety demands. We cannot find justice through a checklist. We need to create what I will call a second look unit, a unit that combines prosecutor-initiated resentencing cases and conviction integrity cases into one unit. And I'm talking about a staffed, robust unit. We have to say that this matters. This is part of justice. Looking back to make sure we haven't made mistakes. We need to be transparent and independent. Independent means never taking contributions from anyone. We have mandated criminal oversight over. Transparent means keeping demographic information about our case filings and dispositions that is readily accessible. We know from a recently published report that the district attorney's record
30 seconds.
is a disaster. We need to fix that, and I will post thousands of data points online so the public can evaluate our performance and see if there's any pattern of bias. Judge Felix Frankfurter once said that the law is a vital agency for human betterment. I could not agree more. That's why I'm running for district attorney. Thank you.
Thank you, Mr. Strunsky. I'm going to rotate the order of questions so that the next question is going to go to Ms. Gressley, then one after that to Mr. Strunsky, and then Mr. Hestrin. Ms. Gressley, in response to recent legislation, the Riverside Superior Court has established several collaborative courts, such as Veterans Court, Mental Health Court, and Drug Court. These courts stress rehabilitation over punishment. Do you support the establishment of these courts as an alternative to incarceration? And if you do, what steps would you take as district attorney to support the operation of these courts?
I definitely support the collaborative courts because I believe that rehabilitation is the key to solving our recidivism problem, which we do have. I don't believe recidivism has gone below 70% in some time. So we need to make sure that when people are coming through the criminal justice system, they're not just getting prosecuted, incarcerated, and then they go back into our communities and they re-victimize people in our communities. We can't have that. It's a public safety issue. So the collaborative courts is a great start. We need expansion of it, actually. I believe that we can work with the collaborative courts to try to expand the eligibility to other programs. And I want to make it easier for people to get into the programs. I want to make it easier for them to complete the program. I want to see people rehabilitated 100% because that is absolutely a priority on my list. And also, I think it's a good start, but I think that we need to be even more proactive about preventing them from coming into the criminal justice system in the beginning. And so I will be proposing a public-private homeless task force that's going to try to tackle the homeless crime problem. I will be supporting any efforts to essentially sit down with people who work on the front lines, who are out there, working with nonprofits and certain agencies to try to figure out why these crimes are happening and try to prevent them in the beginning. Now, if they do come into the collaborative courts, like I said, I want to make it more available, more accessible to them. I think one problem that we see right now is that not everybody knows about the options when they come into court, and a lot of times that happens when they're unrepresented. So I want to find ways of making it clear, issuing a notice from the DA's office to pro pers or representing themselves in court to just give an informational piece of paper that says this is the collaborative courts, these are the programs, these are the eligibility requirements. We encourage you to go speak to a lawyer about that or look this up, something so that they are aware of these programs and what rehabilitation options they may have. I think it's essential because we have a lot of people coming and getting convicted and going out without ever knowing that it was available. And
30
veterans,
seconds.
Veterans are so important in that what they did for us, we need to give them that chance. And it makes sense for all of us to have people rehabilitated. I'd like to see it expanded, human trafficking court. I'd like to see that. And I'd also like to see a youthful offenders diversion program. So those are the things that are just ideas of mine that I want to see if we can somehow make those available.
Mr. Strunsky, the recent legislation that established Veterans Court, Mental Health Court, Drug Court, the courts that stress rehabilitation over punishment. Do you support the establishment of these courts as an alternative to incarceration? And if you do, what steps would you take as district attorney to promote these courts?
Thank you. Great question. Obviously, this is something that we need to incorporate into our criminal justice model. I was the judge in the drug court, and frankly, it was one of the best things I've ever done as a judge. It's amazing to watch people transform when they're given the chance, given the tools to do it. I watched these people who had serious criminal histories and decades of substance abuse come to terms with their problems and fight their demons and actually come out of the process better people. They began paying child support, job training, all the good things that we want to see as far as effective criminal justice and making people good citizens again. But I want to address one other thing, which is the recent proposal for a homeless court that the district attorney has proposed. And it's concerning on several levels. The first reason it's concerning is we heard in 2018 during the debate that there was going to be this new homeless court. And we heard what a fantastic success it has been. There certainly is an Indio-based program that Chief Twist started along with a lot of the providers out there. But clearly there hasn't been a countywide homeless court. I would stress this, the idea that we're going to incarcerate homeless people again is not cutting edge, my friends. That is something that is incredibly regressive. And our district attorney has talked about incarcerating and setting aside beds for homeless people. We know that there's a statewide care court that's been established that pushes these cases into the civil arena where they should be. Homeless prosecution, the homeless problem has no business being anywhere near the criminal justice system. We need to get it out of the criminal justice system. We need to move it to the civil courts, and we need to be humane and realize these aren't crimes. These are people that need help. Let's start doing that now.
Thank you. Mr. Hestrin, the same question to you. Veterans Court, Mental Health Court, Drug Court as an alternative to incarceration. Do you support these courts? And what are your comments on it?
Absolutely support the courts. It's been a big priority of mine to expand and make the collaborative courts a reality. And I'm the only candidate up here that has actually done that in the last 8 years. We have expanded our Veterans Court, Mental Health Court, Drug Court, and now we do have a new homeless court. And I will talk about that in just a minute. But we also are working currently with UCR to bring forth a youthful offender court. So that's already in the works. These things, we have a lot of partners in these collaborative courts, the public defender's office, police departments, the sheriffs. So it is a true collaborative effort. And yes, we try to get the offenders that come through these programs, the services they need, the treatment they need to get at the root causes of their criminality. A lot of times it's mental health issues, a lot of times it's substance abuse issues, and a lot of times it's a combination of both. So these programs are a shining example of Riverside County of what happens when we work together. And they've been a huge success. And I will continue to push these programs out, support these programs, and expand these programs in the next 4 years. Let me comment on Mr. Strunsky's idea. Moving the homeless problem to the civil courts is a disaster that will make it 10 times worse than it is right now. Let me explain. The reason we lost, the reason the homeless population got so big so fast is because after Prop 47, we lost the ability to coerce people into treatment. And that's what we need to do. It's not we're not trying to jail the homeless. Shouldn't be trying to jail drug addicts either. However, we do need to use whatever leverage the criminal justice system gives us to force them into treatment. And many times the homeless, oftentimes, will refuse treatment. And that's the sticking point with the homeless problem. And so I'm not proposing in the new homeless court to jail the homeless, but we are proposing to force them into treatment. And if that means they go and sit in a jail bed for 2 or 3 days so they dry up and they get off whatever drug they happen to be on, we can do that. And that's not cruel. In fact, walking past them every day and driving past them in our fancy cars, that's cruel. Compassion is solving the problem and helping them get off the streets and back to their families and back to being productive members of society. And we can do that with care and compassion through the criminal justice system. The collaborative court will have public defenders there.
30 seconds.
Probation officers there. And so it isn't just the DA, willy-nilly deciding who goes into court. It's a group effort, and you can trust us with this. We've done a great job so far in this county, and we will continue to do so. Thank you.
Thank you. The next question will start with Mr. Strunsky, then Mr. Hestrin, then Ms. Gressley. Mr. Strunsky, the COVID pandemic has caused a backlog of cases set for trial in Riverside Superior Court. The Chief Justice of the State of California, Chief Justice of the California Supreme Court has granted several requests to extend the period of time in which an accused may be brought to trial, but these extensions are about to end. Soon, the right to speedy trial will have meaning again in Riverside County, and there's too many cases set for trial, more than the system can handle. Do you support the suspension of civil trials to address the criminal case backlog? And do you have a plan to triage cases, that is, decide which are most important and should go first? And if so, what is that plan?
Thank you. I need to address one issue that Mr. Hestrin said first, is the idea that we're going to detox people in custody. That is cruel. You cannot detox somebody humanely in a non-therapeutic environment, and there's nothing more non-therapeutic than a prison cell, than a jail cell. Let me go to the question about the backlog. Look, we shouldn't be here. As many of you know, we have 1,900 cases currently set for trial. We have 12 or maybe 13 trial courts. So doing the math, that's about 150 cases for every department. There has been no effort to whittle down those cases and get rid of the low-level and mid-level cases. You talk to any defense attorney, they'll tell you that there is no realization on behalf of the district attorney's office that we are facing one of the biggest public safety crises we have faced so far. We cannot try our way out of this. Literally, even if we tried a case every 2 weeks, it would take us 6 years to try our way out of the current backlog. And that's assuming no other cases come in. If we shut down the civil courts, we're denying those people justice. There's justice there too. People need to get their medical care. They need to get their housing. They need to get their justice in those courts. The criminal justice system should never be taking over other areas of law. We saw that happen in 2010. We saw the case law that came out of that. We have to avoid that. And we are here, and we have layered a public safety crisis on top of a public safety crisis. And there seems to be no realization by the district attorney that this is a huge problem. All we have to do is look at the numbers, and this is a disaster looking for a place to happen.
Thank you. Mr. Hestrin, do you support the suspension of civil trials to address the criminal case backlog? And do you have a plan to triage cases? And if so, what is that plan?
I do not support the suspension of civil trials. We will not and have not and will not ask the courts to close any courtrooms or suspend any trials because of criminal matters. And the reason for that is because civil litigants deserve their day in court just like everyone else. And so it's a part of the larger justice system. So that's never been the plan. I've never said that, and it won't happen. We do triage. We've been triaging cases. We have looked at we do have a backlog. The courts were closed, and every single county in this state has a backlog. And so, yes, it's a problem, and we've been looking at how to solve this problem. We have triaged many cases. You heard in my opening statement that according to the Judicial Council, we disposed, that means settled, more cases than any county in the state of California during the lockdowns except Los Angeles. So that's more than all of the other counties, large counties as well. So we're obviously triaging cases. We're offering the lowest level or the lowest disposition that we can offer. And many times what's happening right now, defendants are trying to get a dismissal. They think if they just hold off and they wait, they're going to get a dismissal. And so it is a problem that we're going to have to work through. A new case, though, came out from the San Francisco DCA recently that I think is going to play a big part. And it's Hernandez Valenzuela is the name of the case. And what it says basically is that a court does not have to dismiss a case under 1382 if the delay was caused by the extraordinary circumstances of the pandemic and the courts did everything they could to stay open during the pandemic. Now, We haven't litigated this, but I think this case is going to provide us with some guidance, and we may end up having to go to the appellate courts for guidance. But here's my plan. We're going to work through every case. We're going to be willing to go to any courtroom to try a case, obviously. So no, we're not asking to close down civil cases. If there's one open, there's one available. If there's a commissioner available, our prosecutors are going to be ready to try the case. What I suspect is that many of these cases, when they see the light of a courtroom, will plead, because we're offering bargain basement deals for many, many of these cases. And so I think there's a way out of this, and we're going to work hard to make sure that we
30
work our way out of
seconds.
it. Thank you.
Ms. Gressley, to address the backlog of cases set for trial, do you support the suspension of civil trials to address that backlog? And if elected, do you have a plan to triage the cases? And if so, what is that plan?
Well, I think I just found something all three of us up here agree on, which is we don't want to suspend the civil trials. Civil litigants deserve their day in court. We don't want to be back in 2009 or 10 or whenever that was. I was trying cases here, and I've never seen so many people sent to Blythe to try a case. So we don't want to be there again for lots of reasons. But we also don't want to be dismissing cases. We don't know how that DCA case is going to turn out to apply since it is new. But the thing is, we cannot dismiss cases. As your DA, it's my responsibility to make sure that justice happens. And that means that people who are guilty are punished appropriate, just like I said. So we can't do that either. We need to settle some cases, a whole lot of cases. And I have a different perspective than Mr. Hestrin on this, because I don't think there's a lot of bargain basement deals going on. And I think that we need to be more reasonable, and we need to stop squabbling over minor, time in jail that's done on house arrest or things like this. We need to settle cases. One idea that I have, I'd like to see the MSC court expanded. We have an MSC court. Maybe we can get more judges doing MSCs, because how many times have we had a case that we've had for months, maybe years, and then we get in front of a trial judge and all of a sudden the case magically disappears. We work out a deal, everybody's happy and goes home, and we resolve the case. Let's do that now. Let's do that immediately to deal with this backlog. So if we had to, though, we would have to suspend civil trials, because I'm not going to be dismissing cases. So like I said, we have to do what we need to do. But that's an absolute last resort, and the triage method should be like it is for when a judge decides what cases to go to the open courtroom first. So you're talking about the most serious of cases, the in custody cases, the older cases, and then you work your way from there.
Thank you. Mr. Strunsky. Same question.
I think I answered that one. I didn't go, yes.
Sorry about that. I got to play judge. So, Mr. Hestrin, you're first up this time.
Okay.
According to the Death Penalty Information Center, in 2015, Riverside County imposed more death sentences than any other county in the United States of America, accounting for 1/2 of California's death sentences that year and 16% of new death sentences nationwide. What are your views about how the death penalty has been used in Riverside County in the past, and how, if at all, should it be used in the future?
Let me first comment about 2015, because it was an anomaly and an aberration. There were 5 death penalty cases in 2015. 3 of them were tried in the year before I took office, and they happened to be put over, the sentencing put over into 2015. So it was a grouping of 5 cases, sort of happened, series of sort of by chance that it all happened in 2015. But putting that aside, I do think that the death penalty in Riverside County has been overused. And during my time as district attorney, I've been the district attorney 8 years. In 2011, shortly before, a little bit before my time as district attorney, but 2011 was the high of death penalty cases in this county. We had 46 pending death penalty cases. Just the other day I checked, and we currently have 15 pending. So we have narrowed the scope of when we seek the death penalty. We have reduced the number of pending death penalty cases. And we've done that by many things by making sure that we only seeking the death penalty on those cases where the facts and circumstances cry out for something more than life without parole. We've formalized the role for defense counsel. Defense counsel comes into our office and makes a presentation to our senior attorneys before we seek the death penalty. And that has made a big difference. There have been many times when they've pointed out things and it's gone the other way. So what I'm saying is I believe in the death penalty. I think it should be an option for certain cases. When you're talking about the intentional murder of a police officer, when you're talking about the rape and torture of a child, yes, I think sometimes that the death penalty is appropriate, but it should be used rarely and only when life without parole is not sufficient. And so we're not trying to be the death penalty capital. And I think 2015 was an aberration because the rest of the time that I've been in office, I've shown great restraint and I've shown that the death penalty is only used and only sought when it's necessary to get justice. And so let me say one last thing. There are many ideas out there about not prosecuting the death penalty, and I understand some people are opposed to it, but a district attorney has to enforce the law. Death penalty is the law of the land, and I have to enforce it. And by saying we're not going to enforce this law or we're not going to enforce that law because we disagree with it, is a district attorney is putting themselves in the position of the legislature. And
30
there's
seconds.
an arrogance to that, and it undermines our system. And so you may not like a law, but you have to enforce a law. And just because a bunch of people in Sacramento have decided to stop doing their job doesn't mean I'm going to stop doing mine. Thank you.
Ms. Gressley, do you think that the death penalty has been overused in Riverside County? What are your views on the death penalty as it has been used in Riverside County in the past? And how, if at all, should it be used in the future?
So I looked at the Death Penalty Information Center online yesterday. I was thinking about this question. And it turns out it was 2017 where there were 5 death sentences handed down in Riverside County. All defendants in those cases were from communities of color. And I looked at every year and just sort of made myself aware again, because I had researched this before, as to how many death sentences had been handed out in Riverside County. There was also a Desert Sun article in 2020 in March that reported that there had been 16 new death sentences in Riverside County since 2015. But what I was focused on was this year of 2017 that I saw on the DPIC website yesterday. And we led the nation, this county led the nation in the death penalty. And what that means is that in this county, more death sentences were handed down than in any other county, in any other state in the whole United States of America. So one thing that you should be aware of when you're talking about the death penalty and prosecuting a death penalty case is that it costs 20 times more to prosecute a death penalty case than it does to prosecute a life without parole case. The cheapest that's been reported prosecution for death penalty is $1.1 million. So these are things we need to think about, right? Because we're in trouble with money in this county and in this state. Now in 2020, there were 3 death sentences handed down. That was just a couple of years ago. Seeking the death penalty, it doesn't make much sense. I agree with that because of what's going on in Sacramento. And it definitely should be the rarest of circumstances that you seek the death penalty. But I agree that as DA, I'm not a policymaker. That's not my job. That's the legislature job. The voters voted for the death penalty was 52%, still wanted to keep it the last time it was voted on. So it's not my job to change that. And I don't believe in blanket policies. I am opposed to blanket policies because when you make a blanket policy about something you're never going to prosecute, you're always going to prosecute, you are
30
essentially
seconds.
telling the voters that you are not going to exercise your discretion. And being an appellate lawyer, I can tell you that that is an abuse of discretion. So when a judge refuses to exercise their discretion on something that is the law, we call that an abuse of discretion. And the same is true for a DA. So I won't make any promises, but what I can tell you is that I will be reasonable and I will be fair and that I do believe it should be a very rare situation.
Mr. Strunsky, what are your views on how the death penalty has been used in Riverside County in the past? And how do you think it should be used in the future?
Okay, as we have now known, Riverside County sends more people to death row often than any other county in the nation. There's even one year, and it might have been 2017, where we sent more people to death row than the state of Texas. So things are clearly out of whack. This is not an anomaly of a few numbers or a few years. We are the leader in many, many years in the entire country in doing this. I've supported the death penalty in the past, and actually I agree with many of these sentiments of Mr. Hestrin. There are some people that the death penalty is the appropriate punishment. But as a leader, you don't just stay on autopilot. Sometimes you have to turn off autopilot and actually make some decisions, actually lead. And we know that death penalty case costs $1 million more per case than a life without the possibility of parole case. So we also know that we have limited dollars, and a district attorney has to decide how to use the resources. What could possibly be the justification for continuing to pursue a punishment that literally has not been imposed since JFK was in the White House in a Riverside County conviction? Understand that makes no sense. And yes, you may be in favor of the death penalty, but it is an exorbitantly priced false promise. And leaders have the moral courage to say it and to not pursue something that is a false promise and is a waste of taxpayer money. Because we waste the money on that, we can't spend it on prosecuting violent crime, victim services, testing rape kits, all the things that we could do with that money. But we're spending it on an ideology now. And there is no chance that somebody will be executed on a Riverside County conviction in the near future. And Mr. Hestrin knows that. He knows that's not going to happen, yet he spends millions of your tax dollars to pursue this false promise. This false promise to the victims. We need to have a discussion with them. We need to sit down and tell them the hard truth. Leaders lead, and those are the facts. There is no justification for pursuing the death penalty anymore, and I will not pursue it if I'm elected.
Thank you. So the questions that I posed today were submitted by different members of the bar. And there was one last question that came in. And a number of people submitted the same question. I've put the ideas together for one final question for the candidates, and rotating again. Question 5 would start with Ms. Gressley. Ms. Gressley, elected district attorneys have staked out a number of different positions in the last few years, some of them called progressive. In one county, the district attorney has refused to try juveniles as adults, only to later admit that in one instance he was mistaken. More than one elected district attorney disfavors the use of gun enhancements and gang enhancements, claiming that these extraordinary punishments, these life sentences, fall hardest on young people in communities of color. What are your thoughts on these issues? And do you believe that all punishment enhancements should be added whenever possible?
My thoughts are that we can't do blanket policies. So it's not a big surprise that I'm saying this, since I just said it a couple minutes ago. We cannot do it that way. We have to do an individualized assessment for each case, for each defendant, because that's what not only the victims deserve, but the people of the state of California and Riverside County deserve that as well. What does justice look like in one case? What does it look like in another? It depends on the person's background. Do they have a criminal record? How terrible was the crime? I mean, there's so many different factors that you must take into account that if you don't take those into account and you just say, I'm never going to file enhancements, I'm never going to try juveniles as adults, I'm never going to do that, then you are essentially not doing your job, in my opinion. Because you know, it's a hard job. You have to sit down and you have to look at the case and you have to think about what's right in this case. Not what can we charge, what should we charge? What is the right thing to do in this particular case? In some cases, that might mean that an enhancement won't be filed. But in some cases, it might mean that it is. There's really no way to know. Now, I do agree that communities of color have been hit the hardest. I agree with that. I've seen it. I've talked to people in those communities, and I understand that is true. And that is why I will be very focused on preventing any racially biased filing. And I will be taking measures to make sure that we have a blind justice policy, is what I'm calling it, so that to the extent possible, the filers in the office are not aware of the person's race. I'm going to do whatever I can to make sure of that, because not only is it super important that we are not doing that, but it's also important that the DA's office is not accused of that the deputies are protected from that type of accusation. So I'm going to take those measures, but I cannot do any blanket policies. I will not guarantee anything. I'm not bought and paid for by anyone. So nobody's going to tell me what to do, what to file, what not to file. I'm going to do what's right, and that's it.
Thank you. Mr. Strunsky, on the use of gun enhancements, gang enhancements, what are your thoughts on the issue? Do you think they've been overused? Do you think they should not be used?
Yes, I think they've been overused, but I think they definitely should be used. Enhancements are a way to differentiate different crimes from each other and differentiate different individuals who are charged with different offenses and have different histories. So they're a way for us to actually get justice in a lot of cases. What the problem that I have is when we're using essentially a checklist, and this is the way filing in the DA's office works. And I file cases in the DA's office, and they go down a checklist. They say, this enhancement applies, this one applies to this one. And they put, and in fact, according to a recent report, the manual actually tells the district attorneys they shall file enhancements if they apply, if they're appropriate. And these enhancements are often the meat of the sentence. They form the meat of the actual number of years that somebody's going to be in prison. There isn't a lot of thought behind this. And we've all seen this in court where a case is filed, maybe a 3 strikes case. And once it gets filed, there's this inertia, right? There's this movement, and it takes an act of Congress to try to stop that inertia and actually correct an error that was made really early on in the process. So, as I said during my opening, I think we should start rethinking the way we're doing the filing. We should start putting the thought up there. Let me give an example. We know that any district attorney, any mid-level district attorney can file a life case, but those have to be staffed for resolution. Let's put the staffing in the front end. Let's make sure we're making those decisions up front so that we're not in a situation where later on we clearly have a situation where it does not warrant a life sentence, but yet we're stuck with that. And it's very hard, even as a judge, it's very hard to stop that inertia of that initial filing decision. And often that is such a preliminary decision made on so little evidence. And we need to make sure that we make good decisions up front, but also that we're flexible and fair throughout the entire process.
Mr. Strunsky, just a follow-up, if I might. How do you think enhancements have been applied to communities of color?
Well, one thing that recent studies have shown us is that when you ratchet up the exposure, the amount of punitive nature of the crime, it disproportionately affects marginalized communities and communities of color.
30 seconds.
And when you ratchet down the punitive nature, it benefits those communities. So we do see that these very punitive enhancements often disproportionately affect communities of color. That's something that we have to be very mindful of. And it goes back to something I talked about in the beginning, which we need really good demographic information within the DA's office so we can make sure that we're not.
Time.
Okay, thank you, Mr. Strunsky. Mr. Hestrin, what are your thoughts on the use of gun enhancements and gang enhancements, the extraordinary punishments like the life sentence cases, the 12022.53D? 2 parts. How do they fall on communities of color and young people? And what are your thoughts about the use of them in every circumstance where possible?
Well, it's not the policy of our office to
file these cases in every circumstance. We give our filing deputies discretion. And the filing practices that Mr. Strunsky is describing, I think are maybe 10 years ago under Mr. Zellerbach or Mr. Pacheco, but not under my administration. We have revamped our filing system, which includes, we've gone to, 2 years ago, we went to blind filing so that our filers would not know the race or the ethnicity of the defendant that they're filing on. And so part of this is that we follow the evidence. So DAs are not social engineers. It's not our job to fix all the problems in society. A case comes in, we look at the evidence on that case, and we decide what's in the interest of justice in this case. And absolutely, we consider, the criminal background. We consider the gravity of the offense. And there are times when we have to file enhancements because that's how we get justice. And I agree with Ms. Gressley, a blanket policy that says, I'm not going to file enhancements because it's too hard on this community or that community is injustice by definition. We cannot have DAs beginning to file charges based on the color of someone's skin or where they live or how much money they have. That is injustice to its core. You either have to follow the evidence or not. And under my leadership, we follow the evidence. We follow the evidence wherever it leads. Doesn't matter if the person who is charged is a powerful person or if it's not a powerful person. We go by the evidence, and you can't begin to start social engineering that. And that's the problem with these DAs in LA and San Francisco and other places, that they've taken on a role that is beyond the scope of what a DA is supposed to do. We need some humility here. DAs are supposed to be one part of the criminal justice system in their county. They're not supposed to be trying to fix all society's problems. Did I answer? Is there a part that I didn't answer?
I think you got it.
Thank you.
So there it is. Those are the questions that we have for our candidates. We've allotted time for each of them to have a closing statement. Because I thought we might go a little over, I narrowed it to 2 minutes. I think what we'll do is let's try for a liberal 2 minutes here. And when you hear the 30 seconds, if you go over just a little bit, that'll be okay. But certainly no longer than 3 minutes. And rotating again, this would start with Mr. Strunsky.
Well, thank you again for allowing us to speak today and for listening to us. These are important times. We're really at a very important point in the criminal justice system. So I'd like to read you a quote because it's why I became a prosecutor and what I think a good prosecutor is. Citizen safety lies in a prosecutor who tempers zeal with human kindness, who seeks truth and not victims, who serves the law and not factional purposes, and who approaches his task with humility. That was former Attorney General and Supreme Court Justice Jackson who said those very words, and I think they so well encapsulate what it means to be a prosecutor. What we've heard today from Mr. Hestrin is it's Sacramento's fault, right? It's not the fault of anything within the Riverside County District Attorney's Office that we have a homicide rate that is soaring, that has gone up well before the times of COVID. He cites one statistic, basically 1 year of our homicide rate being better in certain counties as an illustration that we are a safer county. I think he said the safest county, one of the safest counties in Southern California. By what metric are we the safest county? How are we safer than Santa Barbara? Are we safer than San Diego? Are we safer than Orange County? Are we safer than San Luis Obispo? We're in the bottom third of the counties in Southern California. We're not the safest county by any criminal justice metric.
30 seconds.
Mr. Hestrin has had 2 terms as district attorney. And here are some facts we can't get around. Crime is up at a higher rate here than the rest of the state. His budget is up 53% just since he took office. The attorneys are leaving in droves. A third of the attorneys have left, and we're not seeing that in other counties. He could blame COVID, but that's not what's happening here. And we're facing one of the biggest public safety crises we have encountered with these 1,900 criminal cases awaiting trial and no courtrooms to try them. And we have layered a public safety crisis upon a public safety crisis. And Mr. Hestrin has no plan to deal with it other than to blame Sacramento and ultimately the courts when these cases begin to be dismissed. I ask for your support. We need a change. Thank you.
Thank you. Mr. Hestrin.
So let me start out by saying, unfortunately, Mr. Strunsky is trying very hard to mislead you. So I would encourage you to take a look at the crime statistics for Riverside County, because since I've been the district attorney, violent crime is up in Riverside County since 2014, 16%, but it's up in San Bernardino County, 58%, and in Los Angeles, 28%, and in Orange County, 17%. So, we could go back and forth with statistics, but we certainly, our crime has gone up less than our neighbors and less than our counties of similar size. And, let me just comment on people leaving the DA's office because it's come up several times. Since I've been the DA 8 years, 103 attorneys have left the DA's office. That's a 6% attrition rate. The 8 years prior to me taking office, 154 attorneys left the DA's office. That's an 8% attrition rate. So I guess I get a credit for over 30% improvement in the retention rate. The point is that there's an effort to mislead you. There's an effort to use sleight of hand to have you think something that's not happening. Let me end with this. I've been your district attorney for 8 years. I've never taken for granted the trust you've placed in me. I appreciate everything that this community supports the DA's office. I've been in this office for 25 years. I've never left. This is the only place I've worked. I care deeply about the people that work in the office, this community, and this legal community.
30
And
seconds.
so I ask for your support because we have made this office a great office. We still have work to do, but in the next 4 years, I'm going to work hard and double down on what works and make this office the best in the state and make sure that the county remains, as it is, one of the safest places to live in Southern California. Thank you.
Thank you, Mr. Hestrin. Ms. Gressley.
After all is said and done here at the forum or at the ballot box, it turns out we all want the same thing. We all want to feel safe. Safe from being a victim of a crime. Safe from being wrongfully accused. And safe from injustice. Because we all want peace. And peace comes when you feel safe in your community, when we feel treated equally by those in charge, and when we feel well served by our district attorney. As your district attorney, I will serve with integrity, with transparency, and with perseverance, because I'm not going to give up until real and lasting solutions to the biggest of our problems are found. But if you believe that nothing is wrong with our criminal justice system here in Riverside County, then I'm not your candidate. But I vow to serve you as your DA when I'm elected. And if you believe that politics should have anything to do with the administration of justice, I am definitely not your candidate, but I will serve you as your DA and I will be free of politics. And I will dedicate my career to making sure that righteous justice is done and unrighteous justice is undone, and that your family is safe. People who know me know that I love to quote Dr. Martin Luther King Jr., and the reason is because he represents what I believe in. The fight for civil rights includes the fight for justice for every single person. And so I quote him again,
30
because
seconds.
his words have just as much meaning as they had when he first spoke them. He said, "True peace is not merely the absence of tension, it is the presence of justice." Join me in this cause. Vote Lara Gressley for district attorney on June 7th. I'll put justice first. Thank you.
Thank you. Let's give a round of applause to our candidates. One final comment. There are people fighting and dying for democracy in the Ukraine right now. They're putting their lives on the line to protect this very system that we just saw working. Democracy can work, and with candidates like this, democracy is working. So thank you for being here. Good.